Thank you for everyone who's dialing in early. Nice to see familiar names. Hi, Phil. Hi, Kirsty. Hi, James. Hi, Basil. Nice to see some familiar names. So we'll just obviously wait for people to dial in. And in the meantime, I hope you're all managed to dodge the COVID bullet so far, and it's not causing you too much chaos. How are you, Jane? How are you guys operating? Are you all now in the office, or are you kind of half and half, or have you got a company policy around it? How are you operating?
We're in the office as much as we can, obviously as lawyers, and I think many clients want to have a face-to-face relationship, but we can operate online too. Courts are operating a hybrid system, so we have a number of cases at courts or face-to-face. It's very much trying to get back to normal, but again, they operate a cloud-based platform for those who are unable or perhaps uncomfortable attending a face-to-face hearing. So we're improving our technology, we're moving with the times, which is wonderful. And actually, we follow a client's lead. And if a client wants remote meetings, we'll have them. If they want a face-to-face meeting, then again, we're very happy to have them too. Obviously, we're following COVID rules as well.
Yeah, there was a lot of talk around during lockdown around how legal documents got signed and could they be witnessed on Zoom. Is that now? I understand that's now all possible, isn't it?
Yes, it's possible. The courts have created online platforms for various solutions. In the height of COVID, in the very beginning, there were stories about will signings whereby one party would sign a will on a chair at the bottom of their driveway and then leave the chair, and then another person would go and approach the chair with their own pen and sign. So, the legal profession have had to be quite creative. Done this good, I think.
But exactly. It's good because it's allowing, we've often had problems with sending trusts around the country to different trustees, and whereas actually if it can all be witnessed on Zoom, it can be done a lot easier, can't it?
Absolutely.
So there's plenty more people dialing in now, so we'll just give them a few more minutes to because we're still a little bit early.
I think COVID has changed the way the world operates. I think some of it has been innovation, which has been really sort of ready and waiting and is very, very good. I think it's given us all an absolute shock. And I think for some of us, it's been a bit tough getting used to all the new technology.
Well,
myself included.
We were actually kind of endorsing and embracing this stuff before the lockdown. We were trying to get, particularly our London clients, that, we've got to travel in and out of London to see them, but they're often traveling in from Surrey or the South Coast or whatever it is. So trying to do their review meetings on Zoom just seemed to make sense to us. For many people pre-lockdown, they resisted that. Whereas once they'd got the hang of it and realized that they could be back in the garden 5 minutes after they'd finished seeing us, they didn't have to pay for train tickets and all of that stuff. It worked really, really well. So
there is an environmental argument as well, isn't there? So if you can sort of manage your carbon footprint because you're not spewing out exhaust fumes and you're not spending money on a high cost of fuel because you can have a meeting without downtime, then it makes sense. We have a very large office in Cardiff, and obviously the Welsh government are saying to people that if they can work from home and if they can do so effectively and the clients are happy, then that ought to be a priority, not just to do with COVID, but really to do with an environmental policy and avoiding fuel emissions, which makes sense.
Yeah, it does. It's also doubled my office capacity, so I think that's a good thing as well.
Absolutely. Absolutely.
So it's gone 10 o'clock. So all I'll do a bit of housekeeping as people still dialing in. So that's fantastic. So in terms of housekeeping, if you want to raise a question, the easiest way to do it when we're in this webinar format is to put it in the chat box. So you can just click the chat button, put in the question. You can either send that direct to us or you can do it to everybody, I think. And we will then go through those questions at the end, just so that doesn't get disjointed trying to read the questions as well as present. So you can put any questions you've got in the chat box. you're all muted because of the format, and you're all anonymous amongst in this format. We will be doing a recording, so we will send you a recording of this afterwards, and we'll also send you a copy of the slides afterwards so that you've got that. And then in terms of the view, sometimes we get asked, I'd like to see more of the speaker and less of the slides. I'm not quite sure. I can see why you'd want that when Jane's presenting. For me, I'd just stick with the slides. But that is all in your control. So under the little button view, you can select whether you want speaker view, and you can move how much is slides and presenter. So I am just going to share my screen quickly to do a brief introduction to the webinar. So the webinar, as you know, is leaving a legacy through asset protection. And really, we've often said at Efficient Portfolio that we really want to work as closely with other people's trusted advisors. Because historically, what used to happen was you as the client would have an accountant on one side that would be giving you advice, you'd have your financial planner, and then you'd have your solicitor. And you're getting advice from all of these different sources, but you as the client are then stuck in the middle. And when it's things like whether it's divorce or inheritance tax and things like that, there's actually advice coming from all sources. And often you can be stuck in the middle, not really knowing which way to go. And so one of the things that we've talked a lot about over the years is what we call the trusted team approach, which is where actually all of your trusted advisors come together and formulate a strategy and work together and then present that to you. Because what it means is it brings all of our expertise together, and you get one overriding solution as opposed to sets of advice which can often conflict. So working together as your trusted advisors is really important. And so Jane and I have had many meetings and worked together a lot over the years. And so this seemed like a great opportunity to come together and put together a webinar where Jane can share her expertise around how to protect assets, and I can share mine around how to protect assets and create a legacy. So without further ado, and without any technical issues, what I'm going to do is I'm going to stop sharing my screen, and Jane is going to share her screen and jump into her presentation, and we will I will jump back in later on, and I'll mute myself for now.
Well, good morning, everyone. I absolutely agree. Charlie and I have worked together over many, many years, and we both absolutely are on the same page that teamwork is key. And this is all about looking after your legacy. I think sometimes family law can be overlooked. And I'm going to talk to you about how family law can really help you moving forwards. So first, let me introduce myself. I'm Jane Cowley. I'm a family law specialist. I'm a partner at Geldards, and I've practiced for over 30 years in family law, really focusing on financial aspects of family law and focusing on helping people to manage their estates. I'm a partner in Geldards. We work across the East Midlands. I don't know whether any of you caught the conversation earlier. We've got offices in the East Midlands and also in Cardiff. And we are a very large team. So we are, as a family law team, you'll see a photograph soon showing the entire team. We're ranked top tier in Legal 500 and Chambers, which are the only periodicals you can't pay to get a top ranking in. So we do know what we do. I'm personally named as a recommended lawyer in these publications. As a firm, we provide a full legal service, but I've said we've got a very sizable family law team, which is the slide which Charlie is kindly showing now. I'm also a retained legal advisor for ITV Studios, particularly working with them on their Emmerdale programme. So if any of you are Emmerdale fans, I'm the one behind the storylines, making sure that the legal content is correct. I don't get paid for it, but I must admit it's a huge amount of fun, particularly good fun when I go and visit the studios. I also do an awful lot with business owners and I'm chair of various organisations dealing with businesses. So if we just move on to the agenda slide, this should hopefully give you a flavour for what we're going to cover today. So I'm not going to make you into family lawyers, you have no need for that, but I am going to give you an insight into my world as a family lawyer and hopefully demonstrate how a little knowledge of family law can help you make decisions in order to protect your legacy and protect your wealth. So I'll consider financial claims within divorce. I'll consider protection, which is where I spend most of my time now, advising families on how to protect their relationships in the event of a relationship breakdown occurring. And I'm also going to consider the issue of cohabiting couples and, of course, the bank of mum and dad, the fourth largest lender currently according to the Office of National Statistics. Hopefully I can give you a few stories along the way, a few anecdotes, debunk some myths, and give you a little bit of food for thought. So on the next one, then, let me give you a bit of background. England and Wales is the global divorce capital, largely because of its huge discretion when dealing with financial matters. And I'm not trying to depress you now, but I will say 42% of marriages end in divorce. This is, however, set against the fact that millennials and younger people are choosing not to marry, but to live together as if they are married. So that's against a backdrop of a falling marriage rate. In fact, the rising marriage rate is amongst what we call the silver surfers or the silver splitters, those who are perhaps entering marriage later in life, often having pre-acquired assets which they need to protect. Let me also say that within divorce proceedings, no asset is beyond the reach of the court amongst this huge discretionary exercise, unless it has been protected, and protection will be a key focus of our chat today. I'll just give you a few other sort of facts just to give you food for thought. I don't know where you're dialing in from. I don't know whether we've got people from Blackpool, but if you're there, you've got the highest number of divorces in your area, over 13%. Likewise, Hastings in Sussex and Torbay, for some reason, are the three cities in the UK with the highest divorce rates. So hopefully you're not from those cities. I think Rutland in particular has got one of the lowest divorce stats. So Charlie, you're safe. Next one then. Relationship changes impact us all. So knowing how a family lawyer can help you and help assist you in protecting your legacy is absolutely key. And as I said, we don't just deal with divorce. Increasingly, most of my time now is spent in pre-relation protection and post-relationship breakdown protection. So let's have a bit of a chat about divorce then. And get to the next one, Charlie. I would say to you that the one thing to remember is divorce procedure ends a marriage only. So many of you may have experience from friends, family, or even personally in relation to divorce proceedings. Divorce proceedings start with a document called a divorce petition. The most common reason for a breakdown of marriage is unreasonable behaviour. I've been married 30 years now. My husband could have divorced me on unreasonable behaviour a lot of times, and likewise, I probably could have divorced him too. It's a subjective ground, it's actions which make you feel it is unreasonable. And the key thing to remember is the reason for the breakdown of the relationship is rarely relevant when we look at financial matters or matters relating to children. The breakdown of a marriage is a sadness, and the court's job is to move you forwards, not to apportion blame. Divorce practice ends a marriage. It does not terminate any financial claims. And within a divorce, the courts can make claims in relation to your income, your capital, your pension, your property, your business, any trust assets, No asset is beyond the reach of the court unless it is protected. And as I've said, a divorce itself simply ends a marriage. It does not deal with those financial orders. When you're looking at your legacy, are you sure your legacy is yours, or do you have a divorce but you have not protected your assets within a financial order within divorce proceedings? If you're considering sharing your legacy with family members, make sure that they too have not had unresolved issues, leaving their own financial assets open for a potential claim within divorce proceedings. What you do not want to do is make gifts to others, which could then be subject to a claim where financial assets have not been sufficiently protected. And thirdly, do consider who you believe to be within your family and make sure that it's the same as your family members. So you're not making gifts or making provision for people who could then make your own assets very vulnerable to claim. Financial claims within divorce are costly, they are painful, they are incredibly acrimonious. One way to protect them is to take advice from a family lawyer, and we can advise you regarding how to protect those assets. Move on to the next slide, Charlie, if this is working. So pre- and post-nuptial agreements are absolutely vital, and yes, they do work. And they are not just for the rich and famous, they are not just for the celebrities. I do believe millennials are far more comfortable with the idea of a prenuptial or a post-nuptial arrangement. A prenuptial arrangement is an agreement entered into by two parties prior to marriage, which seeks to set out what should happen to their financial assets in the event their marriage is to break down. A post-nuptial arrangement is exactly the same, but it's entered into post-marriage. Please remember that the process of entering into these documents is just as important as the document itself. So when I was asked recently whether the document could be downloaded from Google Documents and whether it would be valid, or another question was, could it be purchased from the post office? The answer is, well, you may well find those documents somewhere within the internet, but they will not protect you. And relying upon something which is simply not going to be held as valid by a court is very, very dangerous indeed. Consider a pre or a post-nup as an insurance policy. So I'm sure we all have our contents and buildings insurance, our key man insurance in place, our indemnity insurance in place for our buildings. We always hope that we will never have to claim on such policies, but we have them in place as a very sensible precaution. A pre- and a post-nuptial arrangement are just that. They encourage a very healthy, documented dialogue at the outset of a relationship, or perhaps when there has been a change within a marital relationship. They focus on issues such as risk. How do you want your financial assets to be dealt with? If you are considering marriage, what happens if one of you wants to give up your career because you're going to have children? What happens perhaps if there is a family member who is going to gift you some money? How will that be treated in the event of a marital breakdown? Pre- and post-nuptial arrangements are going to be held to be valid if they are entered into appropriately, if both parties have had full and independent legal advice, if there is no coercion, if the process is documented and there has been full and frank disclosure, so there's been absolute honesty on both sides, and they will be held to be valid in the event of a marital breakdown, even if perhaps at that later stage they are deemed to be unfair. I do believe that pre- and post-nuptial arrangements alongside your legacy planning are absolutely vital. Often I will be invited to family meetings where perhaps a parent is wishing to gift assets or property or perhaps business shares to their child, but perhaps the child is in a relationship and they want to make sure that the legacy is going to be retained within their family, within their legacy. A pre and a post-nuptial arrangement can be vital as part of that planning. So please never underestimate it. Younger people are far more comfortable with the prospect than others. Many people say to me, well, it's really not very romantic, is it? It may not be romantic, but if you consider it in the same way as you would a sensible insurance policy, and if you think about the cost of a divorce, this can avoid the acrimony. And when best to reach an agreement, when people like each other, they trust each other, they communicate well with each other, and they're having a very sensible discussion regarding the protection of their family legacy moving forwards. Of course, I've said to you that fewer millennials are choosing to marry. It is more socially acceptable for couples to live together rather than to marry. So how can financial positions be protected in the event couples are not marrying? Well, I'm going to tell you that 69.2% of couples cohabiting are amongst the age of 16 to 29 years. They could be our family, our children, our children's children. And the law in relating to cohabiting couples is a mess. They don't have the same protection as married couples. The courts rely on a hodgepodge of law coming from ancient common law to Married Women's Property Act from 1882, which is hardly up to date, trust law. It's absolutely crucial to consider how cohabiting couples can protect themselves and take the responsibility to regulate what they want to happen in the event of their relationship. And they can do so by entering into something we call a cohabitation agreement or a living together agreement. And this is a contract which two couples enter into with full legal advice, independent legal advice, and they can set out exactly what they want to do in relation to their assets, their properties, their pension, and so on moving forwards in the event there is a breakdown of relationship. Again, a cohabitation agreement or a living together agreement can be a crucial document in your armoury and can avoid a messy, expensive, acrimonious court hearing where all manner of types of law can be thrown into the pot to create a very unhappy relationship. So if you have your children who are perhaps cohabiting or considering cohabiting, or you're wanting to help them along the way, strongly advise them to take legal advice from a family lawyer regarding a cohabitation agreement. It can avoid the acrimony, avoid the expense, and be very powerful indeed. Of course, if they then choose to remarry, it's an easy situation to simply convert it into a prenuptial arrangement. So what of the Bank of Mum and Dad? We mentioned it earlier, one of the UK's biggest mortgage lenders. In 2020, the gifts from Mum and Dad were behind over 50% of house purchases amongst the under 35s. And that's probably because pension freedoms allowed the over 55s to unlock financial assets. And that coincides with the age adult children are often wishing to leave home. And of course, the recent stamp duty holiday fueled a property frenzy and fueled a property climate where lots of people were wishing to purchase properties. All of this served to increase the reliance upon BOMAD, the Bank of Mum and Dad. But think again, when you are wishing to perhaps realise some of your legacies to see your children or your grandchildren enjoy it during your lifetime, who is it that you're gifting to? Is it your daughter, or is it your daughter's boyfriend? Is it your family member, or is it someone who's now living in that property? If in doubt, loan the money, do not gift. In English law, if you gift something, you cannot then take it back. But loans can always be waived at a later stage, and again can be part of a very sensible tax planning, which Charlie will give you excellent advice on. Make a cohabitation agreement or a prenuptial arrangement or a post-nuptial arrangement an essential part of the conversation to ensure that you are gifting to who you want to be the recipient and not a friend or a partner who you do not wish to receive. Be open and transparent. Have family meetings that can be incredibly healthy. I often get pulled into family meetings, which I attend with pleasure, so I can then ask the difficult questions and facilitate a very sensible conversation. Team working is key. Do this in conjunction with your financial advisor. As Charlie said in his initial slides, you as the clients or the potential clients should be at the center of any discussions or negotiations. And it's our job to build a team around you working collaboratively. Remember, prevention is better than cure. It's always best to have a conversation when you like each other, when you're communicating well. It's far more difficult when relationships break down. And when working with your advisor, such as Charlie, to nurture and grow your estate, remember one of the key challenges to the estate you are so carefully cultivating will be a relationship breakdown, but this can be managed with the idea of a cohabitation agreement or pre or post-nup, as I've outlined. So talk to us, let us help you, and team working is key. And I am so sorry for the IT glitches. Thank you for bearing with me. Over to Charlie.
But thank you, Jane. That was really interesting. And I thought the stats were frightening, but the one stat you did forget to mention is that I think 100% of divorces start in marriage. So that is definitely the leading cause. Apologies, very poor joke. So yeah, I wanted to talk a little bit about a very interlinked topic, but which is all about leaving the legacy to the people you care most about. Jane talked a lot about, are you leaving that money to your child, or are you leaving it to the son or daughter-in-law from hell? And so that's really what I want to talk a little bit about over the course of the next little while. But it isn't just about divorce. Is the tax man going to take all of that money that you've you've worked hard to accumulate during your lifetime, and then when you want to pass on that legacy to the next generation, is the tax man going to take a huge chunk? Or maybe even care fees are going to erode that money in the future. And this, of course, I could be talking to you about your own situation, but we could be talking about the generation above you, the inheritance that you may receive being eroded by care fees. And as Jane absolutely rightly points out, is it a divorce in the family, or is it, a divorce of the next generation that means that your hard-earned money disappears away? And then one thing that quite often really is a worry for clients when they're thinking about leaving a legacy is, how much is enough for you? It's all very well giving money away, but how much do you need for your lifetime? And so really what I want to talk about a little bit today is about how you can create the best legacy possible, how you can make sure that you've got enough for your own life in the future, but also so that you can make sure that that money is growing through the generations, is protected down through the bloodline. So that's really what I want to talk about. For those of you that don't know me, my name's Charlie Redding. I run a chartered financial planning business predominantly based in Rutland. We're ranked as one of the top UK practices. We won the top financial planning firm in the Midlands last year, as well as being ranked one of the top UK practices by the Times and the Telegraph. I myself am a chartered financial planner as well. And I'm also the author of 4 books, the first one being The Dream Retirement back in 2015, and then a sequence of which have kind of tried to help different people. But the one that I'm going to talk a little bit about today is the life legacy gift. And I refer to financial planning because it's what we talk about, but quite often people don't really understand what I mean by financial planning. And so financial planning is one of the keys to leaving an amazing legacy. And it's really about understanding what resources you've got available to you today, what's important to you in the future, and delivering a roadmap to achieve that. And so that's really kind of, I know quite often that there's a difference, perceived to be a difference between financial advice and financial planning, but that's why financial planning is different to financial advice. Financial advice tends to be more about the products. I want to tell you a little story that was told to me or said to me by a client of mine, elderly client that I met a good few years ago, and sadly he's no longer with us actually. But he said to me, you know, once upon a time I had a wife, I had children, and I wanted to spend lots of time doing all of these amazing things with them, and I wanted to spend, you know, and that required money. But at the time, I didn't have the time or the money to do all of the amazing things that we wanted, you know, I would have loved to have done. But he said, now that I'm elderly, you know, my wife has passed away, my children live miles away, and yet the ironic thing is I've got all the time and the money that I need. I've got more time and more money than I know what to do with, but no way to enjoy it. And so one of the reasons why I wrote the Life Legacy Gift was really about trying to help people pass on a better legacy to that next generation, because there's actually lots of different ways to do this. And it was it's been a project of mine to try and help clients. We help clients a lot with protecting their assets through trusts and things like that. But there's a lot more to leaving a legacy than just the finances as well. And when I really started thinking about what this project needed to be and how you create the best legacy possible, I realized that there's really three things that you need to do. The first is the sort of general day-to-day admin. You know, when somebody passes away, where's the safe? Who knows how to get into the safe? Who's got the spare set of keys? What's happening to the dog, the children, etc.? There's that day-to-day stuff which actually causes huge amounts of grief to the people that are left behind without the right planning. Then there's their financial legacy. There's the, you know, is it going to go to the tax man or the daughter or son-in-law from hell? You know, how do you protect that financial legacy? But then finally, there's that element of, you know, the non-financial gifts that you can give people, because so often when people die, they end up, you know, their memories, their life lessons, all of those sorts of things are lost. And so what I did was I created what we call the life file, which is essentially the process by which you can make that passing as painless and easy on the people that are left behind as possible. Then I created the Don't Wait Protection Plan, which is essentially how you can pass that money down through the bloodline in a tax efficient and protected way. And then finally, there's the last gift, which is about how you can really pass down all of those non-tangibles to the next generation. And that's what I want to kind of dive into a little bit this morning. I'm just going to start off very briefly with what I call the life file, because this bit is the bit that probably gets the least amount of thought and yet causes the most amount of pain when you're amongst the people that really should be focusing on grieving for a lost loved one. So it's all about things like that, you know, immediate actions that need to be taken, whether it's, you know, the day of death, you know, those first 14 days, who's got the keys, the safe, the children, you know, what's happening to the children, the dog, etc. Then it's all about the family, you know, things like, you know, covering information like the key information you need to pass on to your next generation, the assets list, what insurances are there, all of that sort of admin stuff that is really important. Then there's the everyday practicalities of living, you know, in this digital world. Where are your passwords? How do you get access to things like their social media account, memberships, utilities, all of those sorts of things. And then finally, there's the legal side of things, which is, you know, where's the will kept? Have you got your own business? All of those sorts of elements. So the life file is very much about the practicalities of helping with somebody's estate. But what I really want to focus on predominantly this morning is the Don't Wait Protection Plan, because that's mostly about the financial legacy that we talk about. And to be able to talk about inheritance tax planning, which is something that we help a lot of clients with, we need a basic understanding of what inheritance tax planning is. And so basically with inheritance tax planning, we all get what's called the nil rate band, which is an allowance, which is free of inheritance tax. So it's £325,000 each. So therefore, for a couple, that would be £650,000. And so anything over the £650,000, in theory, you need to think about whether you're going to lose 40% of it to inheritance tax. Now, during the coalition government, they introduced the residential nil rate band, which actually takes that allowance up to potentially £1 million. But it can be eroded for those bigger estates, and for very big estates, it's not present at all. It's a horrible piece of legislation. You can end up costing yourself the residential nil rate band allowance if, for example, you downsize because it's linked to property. So it is there, and it needs to be in the sort of back of your mind so that you don't miss out on that allowance. There are some other allowances that are important. You can have an annual allowance, which is to give money away, and you can use last year's allowance if you didn't use it. You can make small gifts of £250 to different people, and there's gifts in the situation like marriages and those sorts of things. And there are also some exemptions too, in the sense that you can pass money to your spouse, for example, free of inheritance tax, and you can pass money to charities free of inheritance tax. And one of the exemptions that gets missed quite often is what's called gifts out of excess income. So what you are allowed to do is, if you've got more income than you require for your own spending, you can give that money away free of inheritance tax, and it leaves your estate immediately. It does need to be regular. It does need to be out of income, not capital. It can't impact your standard of living. But as long as you meet those requirements, it's quite often a forgotten rule that you can actually give some of this income away for inheritance tax. But one of the things that people are more typically aware of is giving capital away, and that's what's known as a potentially exempt transfer or a PET, as it tends to be known. And when you give money away, as people tend to know, you need to live for 7 years for it to have been free of inheritance tax. And if you give that money away and you live for 7 years, it's free of inheritance tax. It's been really simple, but the problem arises that you've given up control. And as Jane rightly points out, if your children then go and get divorced from the son or daughter-in-law from hell, then that money's vanished from the family. And so really there are alternatives to trying to protect that money. And one of the things I'm not really going to talk about in a great deal of detail today, but Jane alluded to, is that you could loan the money to the children, or you could make that potentially exempt transfer into a trust, and then the trust loans that money to the children, because that is one of the ways that you can retain control, but also make sure that if there is a divorce of your son or daughter, then actually you've managed to protect that money in the best way that you possibly can. So I want to talk a little bit today about very briefly about some of the opportunities around inheritance tax planning. And I often do that by describing inheritance tax planning as saying it's very much like cake. It's like cake for two reasons. One is because with inheritance tax planning, you can't have your cake and eat it. You can't give something away and still benefit from it. We all love, these cakes look amazing, don't they? But if you can't give your a piece of art away, for example, but still hang it on your wall because you're retaining a benefit, it's what's called a gift with reservation. So inheritance tax planning is predominantly around giving up something in exchange for some sort of saving. And the other reason it's inheritance tax planning is like cake is that it's the best cakes have layers. One type of flavoring is not usually the best type of cake. It's actually multiple layers of inheritance tax planning that gives you the best solution. So I want to give you a few ideas of some of the solutions that are out there. And in fact, the first solution I've just alluded to already, and that's what's called this protective gifting trust. So if you want to give money to the next generation, but are worried about them getting divorced or blowing it on, having an amazing Freshers Week, but not a very motivated life thereafter, then what you can do is you can make that gift to the trust. It leaves your estate over a 7-year period, and that money can immediately be loaned to the children so that they can spend it, use it, deposit on a house, whatever they want to do. But you have retained some control and some protection. But it's not very sophisticated when it comes to inheritance tax planning. So the next step up from that is something that's called a gift and loan trust. So gift and loan trust is where essentially you might say, well, I've got £100,000. I don't want to give that £100,000 away, but the growth on that money over the years is going to create more of an inheritance tax problem. So the nice thing about a gift and loan trust is that you can retain the capital, you can retain the income that you initially put in, but any growth is free from inheritance tax and outside the estate. So it's limited circumstances where it's useful, but it's another tool in the armory. One of the ones that is more popular than that is what's known as a discounted gift trust. And a discounted gift trust is essentially where, again, you might say, well, look, I've got some capital, but this time you might be willing to say, I don't need that capital. I know I don't need all of that money for my lifetime. So I'm going to put that capital into a trust. However, I do need an income from it. So the nice thing about a discounted gift trust is it has to give you an income. And the benefit of putting money into that sort of trust is that some of the money, let's say half, will leave your estate immediately. So let's say you've put £100,000 into the trust, £50,000 may leave your estate immediately for inheritance tax, but the remaining £50,000 would leave over that same 7-year potentially exempt transfer route. But throughout your lifetime, you can retain income, usually 5% of the capital you put in. So it's a really lovely way of saying, look, I don't need this capital, but I do need the income, and I want to get my inheritance tax estate down, and so that my children can inherit more money. So this is a really brilliant trust if you need an income. But if you don't need an income, it can actually cause as many problems as it solves, because gradually you just take the money out of the trust and you put it back into the taxable estate. So an alternative is what's known as a flexible reversionary trust. And this is really lovely if you want the option of accessing the money, but you don't think you'll need it. And basically the way this one works is it's just split into 10 chunks of 10%. And each year you can have that 10% back if you need it. But if you don't need it, you can roll it further forward to a future year. So you can have money back if you need it. But let's say you've rolled 5 years worth into year 5. In year 5, you would actually have the opportunity to take 50% back if you needed it. But if you didn't need it, again, you can continue to roll it forward. So it's really lovely in the sense that it gives you that option to have that money if you need it, but you don't have to take it. And all of this capital leaves your estate over that 7-year potentially exempt transfer period. And also the nice thing about this type of trust is you can actually also make appointments of loans to the beneficiaries during your lifetime. Now, I said that you can't have your cake and eat it, and you can see from those trust-based solutions that there's a bit of give, and you're getting some inheritance tax benefits, but sometimes you've got to give up access to the capital and have to have an income. Sometimes you have to give up access to the capital and you can retain, you can get chunks back in stages, but you are giving up something. But because the money is in the trust, you can do what you want with it within the trust. You can have it in a traditional investment portfolio, you can have it in cash. You can't really have this in property for these types of trusts. It gets very messy. But you can have it in most of the traditional investments. What you're giving up is that accessibility. An alternative to inheritance tax planning, another good layer to our inheritance tax planning cake, is the business property relief solution. And business property relief is all about, so if I want to leave my business to my children, if I want to leave a fishing portfolio to Fiona and Bronwyn, my daughters, then I can do so without inheritance tax. But I'm not suggesting that you necessarily go out and set up a business in retirement just purely to pass your money down to the next generation. There's a similar relief actually for agricultural land called agricultural property relief. But again, I'm not suggesting you go out and buy farmland. Unlisted and unlisted classed as on the main exchange of the FTSE 100 and FTSE 250. Companies qualify for inheritance for business property relief. And the benefit of business property relief is that once you've held that asset for just 2 years, not 7, but 2, then it's free of inheritance tax. And not only that, it's still your asset. So if you want to spend it in the future or draw an income, you can do. So investing in companies that are on the AIM exchange, like some of the ones listed here, is a way to mitigate inheritance tax in just 2 years. However, you would pick up on the fact that these are all would be considered fairly high risk companies. You know, they're familiar names, but I wouldn't want my children's inheritance relying on Boohoo and Fever Tree Tonic. And so actually there are ways to get business property relief where they've specifically targeted trying to generate the least risk possible. And those often are around things like renewable energy, storage businesses, businesses where there is security. So with renewable energy, that security is a guaranteed income that's provided by the government. Clearly, the government could change their mind in the future, but at the moment, that provides good security. Storage company, it's mostly around a property. So if the company goes bust, the property is still there and is still valuable. So there are ways to get business property relief that will mean that you can have still own the asset, but you've got money outside of or zero rated for inheritance tax in just 2 years. Now, I wouldn't want all of my children's inheritance based on this type of investment because it's considered to be a much higher risk type of investment. But when you combine it with those other trust type solutions, they can actually work really well. There are some more aggressive inheritance tax planning strategies out there. For the vast majority of people, we would say still stay well clear of them. The revenue is not, it is not keen on more aggressive strategies. There's anti-avoidance legislation in place. Unless you've got a huge amount of money to try and protect and you're willing to take some gamble with paying large fees that may or may not pay off, then we would tend to say avoid most of them. Now, all of the things that I've talked about so far involved cash. So if you've got cash, you can put it into trust, you can put it into business property relief, but it doesn't solve the problem for property. Property is actually really messy when it comes to inheritance tax planning. It's really difficult to put property into trust. It's not difficult, it's just expensive from a tax point of view and often from a fee point of view as well. And you will often trigger your capital gain when you put it in, which stops a lot of people doing it. So property, it is possible to put property into trust, but it needs careful planning and it's not straightforward at all. So where you've got a large primary residence, or you've got multiple buy-to-lets, there is actually one type of planning which is probably the easiest route to go down. And that's what I think of as last chance saloon. Our industry tend to use it as the first port of call, which is essentially to use insurance to provide the amount of money that's going to be payable in tax in trust, so that the assets can be passed down through the generations. But I personally think it should be the last port of call as opposed to the first port of call. I think you should where possible, use things like the business property relief and trust solutions to get the liability down as much as possible, and then ensure remaining liability. But with property, as I said, it can often be difficult to get it down low. So therefore, ensuring that liability is actually usually the next best solution. But as I said earlier on, the difficulty with leaving a legacy and passing money down to the next generation is, what's going to be lie in the future for you. How much money are you going to need? Are you going to end up in care? How much money are you going to need, or is the generation above you going to need? And so one of the keys to financial planning and having a clear understanding of your financial future is a tool that we use with clients, which is called a lifetime cash flow forecast. And it's where we model an individual's life from a financial perspective. I'm not going to bore you with any great detail on these, but I will just explain the two key charts of a lifetime cash flow forecast. First is the income versus the expenditure. So this is somebody's life model through to age 100. Now you may be thinking, I don't need, I'm not going to live to age 100. But what you do want to do is plan to live to age 100, because you don't want too much life at the end of your money, because that ends up in an awkward situation. So on this chart, what you can see is the black line is that runs along the top here is this person's expenses. Blue blocks are the amount of income they've got available for each year. Blue is good because there's enough income to meet the expenditure. Red is bad. And by the way, this is actually a genuine client of mine. This is a lifetime cash flow forecast from a genuine client. He's world famous at what he does. And you would be amazed if you thought that he was on track to run out of money even though obviously in this situation it was in his mid-90s. The second key chart is what's called the liquid assets chart, which is essentially what's going on in the background. How much money has this person got in their investments, savings, and pensions during each of those years? And the reason that that person ran out of money or ran out of income in their mid-90s is because they've spent it all, quite obviously. So the liquid assets chart is just showing us what's going on in the background. But one of the brilliant things about lifetime cash flow forecasting is we can then model different scenarios. So for example, with this client, we were able to model revamping all of his financial planning. We didn't ask him to save more or spend less. All we did was reorganize what he was doing. And we can immediately get rid of that red block at the end. But more importantly, we can actually get the liquid assets to the point where instead of, if he lives to age 100, instead of his children inheriting none of these assets, there's actually in today's money another 1.4 million pounds there to inherit if he just managed that solution differently. And that's one example of how we can model different scenarios. But at the golf club, I play golf at a course where the joke is that they keep the flag at half mast just in case, because it's quite an elderly golf club. I bring down the average age by quite a considerable margin. But quite often when I'm playing golf with some of the older members, they talk about ski holidays. And I didn't realize until more recently, but ski holidays don't have to involve snow because it actually stands for Spend Kids Inheritance. So that's what they talk about at the golf club. And of course, that's what we can model into cash flow forecasting. We can model doing the bucket list, doing all of these amazing experiences, and yet do we still have enough money if we live to 100? And absolutely, the key to modeling is understanding those scenarios. And that could be in inheritance tax planning. And the reason I share this with you is because the thing that stops people doing inheritance tax planning more often than not is the fact that they can't get their head around how much money they'll need in the future. This is the solution to understanding how much money you need in the future. You model different scenarios. What if it doesn't grow as much as we expected? What if I need care fees, etc., etc.? That gives you then the comfort and understanding to allow you to do the inheritance tax planning. And inheritance tax planning has evolved over the years. One of the most valuable assets you now have for inheritance tax planning is your pension. So we tell our clients to usually spend their pension last as opposed to first, because the money is it's a brilliant pot of money that you can say, well, look, if I need it at the end of my life, I will spend it. But if I kind of avoid spending it and spend other things, then that money is sitting there free of inheritance tax. If you die before 75, it's free of both inheritance tax and income tax, because of course you've never paid income tax on that money. If you die after 75, it's still free of inheritance tax, but the recipients will pay income tax as and when they draw it out of the pension. But they can use it very much like their own pension. The only difference is it doesn't contribute towards their lifetime allowance. So it's a really brilliant tool to be passing money down through the generations. ISAs, on the other hand, are a bit of a trap, because actually we spend all of our lives being educated that we must use our ISA allowance. It's really valuable. And then people get into retirement and they go, I can't spend my ISA allowance. In fact, I'm going to take money out of my pension to put it into my ISA allowance. The problem is they're taking money from an inheritance tax-free environment and putting it into an inheritance taxable environment. So actually, you really need to spend those ISAs in retirement to be able to generate the best legacy possible, because that can then preserve the pension instead. And of course, one of the last things that can really affect that the legacy that you lead is inflation. We're running it at about 4% inflationary environment at the moment. But if anybody can just if you send me a quick message if you're getting 4% in your bank account at the moment, then I'd be really grateful. I suspect I won't have many messages in the chat box saying that you are. Because of course, putting money in the bank is not giving you 4%. It's not even giving you 1% usually. So by having money in the bank, you are watching that legacy erode year on year because inflation is eroding it. It may not be going down in money, in numerical terms, but in terms of what you can actually buy with it, the money is going down. And so that's another sort of the silent killer of legacies, that you really need to make sure that you're getting that money growing faster than inflation. And that doesn't mean you need to take lots of risk, but it does mean investing in a properly diversified portfolio. So I appreciate that's a really kind of whistle-stop tour of the Don't Wait protection plan. I just want to touch on one element of the last gift, which I said was really all about passing on the wider legacy, not just the financial stuff. And I often talk about it in the sense that we need to leave a legacy, not just a will. You know, we can write a will, and a will is really important, but actually we can leave a legacy in so many different ways. And one of the examples that I actually even put in my first book, The Dream Retirement, was the Grandparent Interviews. So back then I did an interview with my parents and my in-laws, which was just, you know, what was life like growing up? You know, what did you learn from your parents? What were you, why did you end up doing business that you were doing? What were the funny stories of when you were growing up? Because wouldn't it be amazing if you had today a video of your great grandparents talking about what life was like when they were growing up and what they taught your parents and all of that amazing stuff which has been lost. It would be absolutely brilliant to watch that, and you could show it to your children and your children's children. But of course, the technology didn't exist to do it back then. But nowadays, we're all wandering around with it in our pocket. That's all we need. We can put it out there. In fact, the examples of my parents, what we call the grandparent interviews, for my parents and my in-laws are on the Efficient Portfolio website. And the questions are in both the Life Legacy Gift and in the book, The Dream Retirement. Because there are so many ways we can leave an amazing legacy that isn't just about the money. You know, my granddad, Gerald Redding, decided to set up a farm on the edge of Corby in 1939 against his family's advice, because actually it was predicted that Corby would get bombed during the war because of the steelworks. That actually came true, and they ended up with housing soldiers on the farm. But you know, my granddad was an entrepreneur. He set up the farming business that went down as far as my parents and my uncles and my cousins still run that farm today. So he had an entrepreneurial flair that allowed him to pass on, that he could pass on as a legacy. But he also very kindly, on his passing, he left most of the money to his children, but he left some to his grandchildren. And it was that money that he left, the share that I took of that, which wasn't a huge amount of money, but it was that money that I used to go traveling after I finished university. And it was what opened my eyes up to a world beyond agriculture, ironically, and how I fell into financial services, almost by mistake. But it was thanks to that investment and legacy that he gave me. There's lots of different ways that you can leave a legacy, and actually leaving a legacy with a warm hand. So during your lifetime is even more powerful, because then you can see that people enjoy it at a time when they need it most. My grandmother, on the other hand, Eva, Gerald's wife, was left a legacy in a very different way. She wrote a really lovely booklet up, which I didn't pay enough attention to when I was in my teenage years. But now that I've gone back to it, it's absolutely fascinating about what life was like growing up on the farm and what it was like when they had tanks going up and down their drive. And it's quite an amusing part in there where a busload of Indian soldiers arrive. And so, you know, that was not an expected sight in Dean, Northamptonshire. It's absolutely lovely. And there's so many different ways that you can leave that legacy. She left it by writing up stories about what it was like growing up in Dean and being in Dean during the war. And those stories would be long forgotten now had she not taken the time to do that. There are so many ways that you can leave a legacy, and only some of them revolve around your finances. So I hope that just gives you a brief taster of what we are all about at Efficient Portfolio. It is about creating a legacy. It's also about creating a better future through inspirational financial planning. We'll take some questions in a second, but before we do, if you would like a copy of the Life Legacy Gift, which was, as I said, was just published earlier on this year, if you send me an email, and my email is on the screen there, but charlie@efficientportfolio.co.uk, you send me an email, we will post out and send me your postal address. I will send you a copy of the Life Legacy Gift. Whether that's for you or your parents or your in-laws or whatever, then I hope that that can help you create an even more powerful legacy for the people that you care most about. So thank you very much for listening. We'll go off to the chat box now. If you would like to put any questions in there, I'm going to stop sharing my screen so that you can see us. If you've got any questions relating to what Jane and I talked about, then please put them in the chat box. I can see there's a couple of questions that are already here. Let me just have a quick read of them too.
I can add something. I think almost the greatest legacy you can give your family and your loved ones is your time, is your knowledge, is your wisdom. And a very simple thing to do when you're doing your will, please make sure you have a letter of wishes there so you can explain the reasoning behind maybe the bequests and the instructions that you are making in your will. And you can make your letter of wishes as personal, as lengthy as you like. They don't have to be in writing necessarily. I've known people who've left recorded letter of wishes, and there's nothing more powerful than listening to your loved one's voice after they've passed. Truly emotional indeed. So you can be creative.
It's a really good point, actually. And one of the things I put in the book is about leaving a message with money, because we've had quite a few people over the years that have come to us with an inheritance, and they are so petrified about what they do with it because they feel like it's been bestowed on them and they're now responsible for that. And quite often they won't spend it when they actually need to spend it. And so, it might be a message with the money, just saying, if you want to use it for school, use it for school fees or education or whatever it is, then actually that gives them permission to use it in the way that they would have done had they not attached this other emotional link to it. So yeah, it's a really good point, Jane. So I've got a question here for you, Jane. It's been suggested that I can obtain a divorce online. Why do I need a family solicitor?
Oh, what a good question. Yes, you can obtain a divorce online. You pay your court fee of £553, I think it is now, and you can obtain it. But remember what I said, a divorce dissolves a marriage. It does not dissolve the financial claims which can be made against you, and they can be made against you at any time. So I would say you do need a family solicitor in order to ensure that your financial assets are protected. And let me just give you one little example of a case I dealt with many, many years ago. So a gentleman came to see me who was in his 70s, who had been cruising and who'd come back to find his assets had been frozen by order of the court, and he wanted to understand why, and my job was to unravel and find out what had happened. And it transpired that this gentleman had been divorced many, many years previously. He lived in southwest London. He had very limited assets at that time and lived in a rental property with his then wife. Their local solicitor dealt with the divorce. There was no financial order in place. Wife left the property, tenancy was transferred into my client's name, and then Margaret Thatcher introduced the right to buy scheme, which enabled my client to purchase the property from the council. The only restrictions were you had to reside there for 5 years in order to retain your discount. And he was in London and the property prices went sky high. So for the first time in his life, this gentleman, post-divorce, had serious money and started to enjoy it, which included holidays cruising. Remember, he had been divorced. There was no financial order in place. And so when he came to see me, the reason why his assets had been frozen by order of the court was because there was no order in place, and wife, for many, many years previously, ex-wife, had made financial claims within divorce against those assets because she'd heard that he was cruising the high seas and he had money. A salutary tale for all of us. The amount she got was significantly discounted because there was extensive delay, but nonetheless, a gentleman in his 70s suddenly had his whole life shattered, extensive legal fees, lots and lots of upset for something which could have been avoided. So for the person who's asked the question, the answer is a family lawyer will protect your legacy, will protect you financially. So you may be able to deal with your divorce yourself, but you certainly do need a family lawyer.
Okay, brilliant. Thank you, Jane. Another question just here. When thinking about using a trust, what is the minimum amount we should think of as being economic in terms of the set-off between professional fees, i.e. setting up and ongoing, versus the IHT saving? I'm happy to take that, but you will, I'm sure you'll have the contribution as well, Jane. So when I don't think about so there is clearly an amount that is that, and I'm not quite sure what that amount is, if I'm totally honest, but don't think about, I think what you're thinking about is the fact that you've got to be putting money into the trust today. So what we will quite often set up pilot trusts, which is where there's literally a £10 note sat in the back, but they are then sitting there dormant, waiting to receive money on somebody's passing. So I think if you're talking about it with regards to a gift to the children, you'd probably say a gift over something like £20,000, it would be worth putting a trust in place for. Some people would say that figure would be £50,000. But bear in mind that the trust could also be receiving the benefit, the future benefit from your will. So actually, the figure might well be that you can leave significantly more. I don't know if that answers your question, because it also depends on, I suppose, how much of a priority protecting that asset from the son or daughter-in-law from hell is. If you've already got the son or daughter-in-law from hell, you may actually decide that £10,000 is the gift that you want to protect through a trust, because you've got very little confidence it will stay there. But I don't think there is a straightforward answer to that. Jane, do you want to add?
I would say it's a question of balance. I would look at a trust as a medium to long-term mechanism to use within planning, not short-term. So I think it's not just looking at the amount initially to go in the trust, it's looking at the amount of time you want to continue that planning over. What I would say from a family law perspective, one of the things I quite often see, again, is people using templated trust documents, whereby one of the standard clauses might be that a class of beneficiaries will include perhaps your child and their spouse. Do not use templated documents, and that can cause huge issues when perhaps there is a relationship breakdown, which I'm then dealing with, because part of the consideration for a court are the assets which a spouse may claim against, so whatever those family assets are, or equally an asset which a spouse may lose because they cease to be a spouse. So by using a templated trust document and including the usual automatic wording of my child and their spouse, you are automatically putting that asset within the reach of the court, when simple rewording and perhaps naming it, giving it just to your child upon certain conditions would give some protection. So again, it goes back to the whole point of team working closely with Charlie, working closely with a family lawyer, because often the devil really is in the detail, and a simple, excessive word can create massive, massive issues.
Brilliant. So a question that's come in, which could be answered by both of us actually in different ways, is can you use lifetime cash flow forecasting to help through the divorce process? So I'd start off by saying yes, very much so. It is, I think, is a really powerful tool in the process, not just from a legal settlement point of view, because you can obviously use it as evidence to say, well, look, 50% isn't enough, and here's your evidence that I'm going to run out of money in my 70s and my life expectancy is 85 or whatever it is, on a 50%, and here's what 60% looks like. So you could use it as evidence for that, and maybe Jane could comment on that in a second. But the other thing that I think is the trick that's missed by a lot of people through the divorce process is, in my experience, people spend the whole divorce process, or often a lot of people spend the whole divorce process worrying about the money. and worrying about, am I going to have enough at the other end? And in fact, I have a client that was getting divorced, and her settlement was £8 million, which is a lot of money, but she still had that exact same concern all the way through the divorce. Is that enough money for my lifetime? And so actually what we would suggest is that we get that lifetime cash flow forecast built really early on, as early in the divorce process as we possibly can, because that not only can it be used as evidence, but it can also be the peace of mind that actually it's going to be okay. And you can take one of the financial, one of the worries of the divorce process away, i.e. the financial worry, by cash flow forecasting at an earlier stage in the process. What experience have you had with working with cash flow forecasting, Jane, and how are the courts reacting to it? Because I think it's changing over time, isn't it?
Well, collaboration is the key word again, and I completely agree with you, Charlie. I think it's so essential for a client to have a team around them and for their financial advisor and their lawyer to be working in sync. Let me just recap upon the 3 stages of obtaining a financial order within divorce. The first stage is disclosure. So what are the assets? All cards on the table. A bit like doing a jigsaw puzzle. You wouldn't start to put your jigsaw puzzle together without getting all the pieces out of the box. That's the disclosure process. Equally often one of the most painful parts. Work with your financial advisor. We need help there. We need to understand what the assets are. What can they do? Can they produce an income? Can they be realizable? What are the tax consequences of doing so? Part of the process. The next stage, where cash flow forecasting is essential, is starting to look at proposals, looking at negotiation. What is it that you think you need, that we believe you need moving forwards? And then the third stage, the final stage, is hopefully we've reached an agreement and we implement, again, cash flow forecasting. Remember, I also said that no asset is beyond the reach of the courts. The courts within divorce proceedings can make orders dealing with income, capital, pension, property, and so on. Sometimes there may be consideration as to, shall I give you a greater lump sum, but in return you will not be getting maintenance, you will not be getting direct income provision. That's where cash flow forecasting comes into its own. What can an asset produce by means of income? What is realistic? Can we sort of forecast, and if it's going to produce 3% or 5% or 7%, what will then look like? What assets might you need to then draw upon in order that you have a secure financial future? So working hand in hand, using tools such as lifetime cash flow forecasting, but also the knowledge and the wisdom of your trusted IFA, the knowledge and wisdom that Charlie brings as a team in collaboration, is the best way to ensure that you achieve that financial security. So endorse everything you say, absolutely vital.
Brilliant, thank you, Jane. There's a question here for you, I think, really. We were divorced many years ago, all amicably. We sorted out the finances together. Should I be concerned now, given what you've been saying?
I think you need to make contact with me. I think it all depends on whether there is a financial order in place. If there is no financial order in place, it's not too late. There's no time limit. It can be achieved. Remember my anecdote about the gentleman who'd been cruising. I'm not suggesting that anything will be as difficult as that case was, but certainly I think you need to have a word. There is no time limit on orders which are made within divorce proceedings, so they can be made any time afterwards. So what I wouldn't want you to do would be to accrue and be growing your nest egg, to be growing your legacy whilst leaving it vulnerable, because you've dealt with divorce proceedings, you've obtained your decree absolute, you're no longer married, but you have not protected yourself financially, and those claims can still be made, but they all equally can be resolved. So I'd say get in touch, let me help you.
Okay, fantastic. Thank you, Jane. And one final question, unless anybody else wants to add any more while we go through this one, is, which I think is for me mostly, now that we can pass pensions on more easily, is it possible to protect pensions from divorce of the next generation, because we already talked about that a bit. Yes, it absolutely is. So one of the things that we would do for most of our clients is set up what we call an asset preservation trust. So if they die before 75, we tend not to do it beyond 75 unless asset protection is the absolute driving force, because it's slightly less tax efficient. But below 75, if you pass away, and instead of leaving the pension to direct to the children or direct to your spouse and then to the children, you can actually leave it to a trust. That trust then provides an extra degree of protection in passing it down through the generation. It gives more flexibility in terms of taking money out of the trust via a loan, as I already described, which means if there is a divorce in one of the future generations, then that's a loan from the trust. Now, I understand that, and Jane can, I'm sure, add to this, that a court can see, look at the trust assets and take account of that in a divorce settlement. I don't think they can actually give the trust's assets, but they can say they can offset with other assets, can't they? But it's my understanding is it's still a significantly better degree of protection than not having it in the first place.
Yeah, let me talk a little bit about trusts and divorce. Everything needs to be disclosed within that initial process I outlined, within the disclosure process. So you may have an interest or a potential interest within, say, a discretionary trust. It must all still be disclosed. What the courts can then do is look and examine the pattern of behaviour of that trust. So have there been previously gifts of capital or provision of income from that trust? If so, on what basis have the trustees exercised their discretion? So how the trust is operated in practice is going to be really, really key as to how that trust asset may then be dealt with. If, for example, there have been regular provision of income or capital, but then there's a dodgy relationship and that provision suddenly stops without good reason, that's red flag, that's highly suspicious. You're going to make a court very interested in the trust. A court cannot automatically get the trust assets, but they can exercise what they call judicial discretion. So they can put pressure upon the trustees, including inviting the trustees to attend court and making them parties to get to the bottom of how that trust has operated. So in the example Charlie's given, I would be saying, first of all, any decisions of any trustees, record them, explain why you're making that decision, especially when it's a family trust, even more reason to have any decisions minuted and recorded and retained. Explain why you're making provision or why you're deciding not to make provision. There may be a very good reason. There may be another potential beneficiary who has a greater need. And as long as you record it, so it's less ad hoc, we'll see the way the wind is blowing and we'll make a decision, and more formal business, well constructed and rational, then you should be okay. And of course, trust assets can be ring fenced, and that's the process whereby if you're not using the income or capital as a family because you don't need to, then it is far less likely to be looked at within the context of a divorce. Again, prevention is better than cure. Have a conversation. But a trust can be a very powerful document, a powerful structure. It gives an extra layer of protection, but it's how that trust operates in practice which is key, and that's what your family lawyer will want to know.
Brilliant. And there is one final question that's just come in from Chris. Thanks, Chris. Can I take the 25% tax-free cash from my pension and still pass the fund down free of inheritance tax? Absolutely, you can. Yep, good news. You can just take the 25% out. You can even take some of the money out as income, and it will still pass free of inheritance tax and free of income tax if you're under 75, and free of inheritance tax, but subject to income tax of the recipient if you're beyond 75. So yeah, you can still take 25% cash. It's basically what's ever left in your pension, as long as it's a drawdown pension, as opposed to, you haven't bought an annuity or something like that. But yes, no, absolutely, you can. Good question. Thank you.
And Charlie, I've had a request for someone who wants to have a look at your other books. Are they able to email you and they can, would you be kind enough to give them a link to your other books?
Very happy to do that. If you send me an email to charlie@efficientportfolio.co.uk, more than happy to send you one of the other books. So basically we've got, in kind of life sequence, we've got Smart Money, which is the people at the start of their financial journey, the Entrepreneurial Happiness, which is for business owners, the Dream Retirement, which is for people in the lead up to and at retirement, and then obviously the Life Legacy Gift, which you now know a little bit about. So yes, if you send me an email, then more than happy to send you a copy of that too, or one of those two. Well, I think that's it. That's all the questions that I can see, unless you've got any others sent to you privately, Jane. So just want to say thank you to everybody for dialing in. We will send you, I said at the start, but we'll send you a copy of the slides and also a copy of the recording in case there's any bits that you want. And on that, you'll have Jane's details and my details if you want to get in contact. If we can be of any help, then please don't hesitate to ask. And if you know of somebody else that we can help, don't keep us a secret either. Yeah, huge thank you for you dialing in, and I hope you have a fantastic rest of the day and the rest of the week.
And a final thank you and goodbye for me. And if any of you want to contact me on a completely confidential, no obligation, quick question or a chat, then feel free to do so. I know some of the questions raised this morning may lead you to want to have a further conversation. So no charge, no obligation. Would be really, really happy to hear from you. And again, do this because, Charlie and I have worked together an awful lot in the past. We go back a very long way, and anything I can do is to support Charlie in giving you the best advice to protect your legacy. I will do so with pleasure.
Brilliant. Thank you very much, everybody. Thank you, Jane, for joining me. And yeah, get in touch if you need us.
Take care, everyone. Bye-bye.